Well, greetings, everybody. It is Monday. It is 6 o'clock, and I'm attorney Brian Burke with Sam Shehab and Associates. Conspicuously absent is my dear pal Sam. He is traveling at the moment, so we have some good stuff in store for you, though. Sam and I, we had a little bit of notice on Sam's travel, so we had a really good talk about the subject of tonight, the green card EAD, but also I think we have a really good sort of current events topic to talk about. USCIS has issued some recent FAQs on their processing of green cards during this fiscal year. So stick around, got a good update from USCIS and a great topic of green card EADs. Well, welcome everybody. Once again, I'm attorney Brian Burke with Sam Shehab and Associates, and our main topic tonight is the green card EAD and all the fun stuff that comes with that. But the interesting thing I wanted to bring up is on Friday, USCIS on their website issued a new FAQ regarding the processing of I-485s for employment-based folks in the fiscal year 2022. And I think we're going to have to do some more analysis on this in the future, but I think there's some interesting highlights that I wanted to show you guys and talk about them right now. Here they come. So on their website, on the USCIS.gov website, you can find this as well, but I have a nice PDF copy of it here with some highlights of the sort of things that I wanted to share with you guys. So these are frequently asked questions regarding the employment-based adjustment of status process in the fiscal year 2022. And let's see here. There's a question here that the USCIS poses. Is there any estimate for how many family-sponsored or employment-based immigrant visas USCIS and DOS will use during fiscal year 2022? They don't really comment on that, but the interesting thing I wanted to highlight here is how USCIS says they're doing this year on the use of the approximately 280,000 green cards that they have available this year. And they said that as of mid-June 2022, USCIS and DOS have used significantly more visas than at the same point in fiscal year 2021, with USCIS alone using more than twice as many visas on a weekly basis than it was at this point in fiscal year 2021. And this is the best part of it for me. As a result, we are well positioned to use all of the available employment-based immigrant visas in fiscal year 2022, despite the higher annual limit, the more visas available this year. So there's a lot in this statement to unpack, and I have a sort of a bit of a PowerPoint slide on the subject. So basically, and here it is. USCIS, in fiscal year 2021 through about June, they actually, I just looked up this data, did 74,734 employment-based green cards USCIS. And as of, per this FAQ, with 3/4 of the fiscal year complete, about 3/4 of the fiscal year complete right now, USCIS says they're significantly beyond the 75,000 that they used last year. That's pretty good. I like hearing that. And now they say, as of this week, they're currently on a pace that's double what they were at last year. As of this time last year, pretty good. But in my notes there, I just can't help but notice that USCIS this is some good data, it's some interesting data. It's saying they're doing better than they were last year, but they still haven't given us their actual hard data for even Q2 as fiscal year 2022. And that's something I'm really interested in seeing, because as you guys have watched our past presentations, you know that I really, really, really love diving into the numbers and seeing how USCIS is actually doing amongst their service centers and field offices. So basically, in a nutshell, USCIS, they're talking a big game, like they're going to be able to issue all these green cards for fiscal year 2022. I like the sound of that. What else do we have here? So they also sort of comment on some of the things that have been slowing them down, and they say that missing or invalid Form I-693 filings, that's medical exams, are holding them back in improving cases. Last week, Sam and I were talking, and we were aware of this because USCIS brought up this issue in an ombudsman liaison with AILA a couple weeks ago. And the logic was, well, gee, it sounds like if you haven't sent in your medical exam, get them to USCIS. However, if you scroll through this FAQ a little bit while more, USCIS says, hey, don't do that. They say it's likely that unsolicited Form I-693s, as in without an RFE, will be difficult to match up with the adjustment of status case in a timely, efficient manner. So right now, USCIS is saying, unless we're asking you for your medical exams, don't send them to us because there's a good chance that we will have trouble figuring out where they go and it might slow us down. So it's an interesting update from USCIS. This is despite how their policy consistently says, we will take your medical exams anytime while your case is processing. I guess they don't want the administrative burden that comes with hunting down your case. So again, going to hit a couple of the other highlights from USCIS here. These are things we know, but it's interesting to hear them say them outright. So USCIS says they've been working collaboratively with the Department of State to ensure the visa bulletin has been advanced to allow for filing and adjudication of significant amount of green cards. So that's USCIS saying, hey, we're working with Department of State, who publishes the visa bulletin, to push those priority dates, those final action dates forward. It's pretty rare that we get insights as to their direct communication and coordination on this, so it's something I like to hear. I thought it was interesting. Thought you guys might want to hear about it. They also, on that same note, mentioned that, hey, we've been actually pushing you to move into the EB2 category because we lack sufficient inventory of cases to use all of our green cards in that category. So again, this is them hammering that, we published communication materials in January, February, March, and April, notifying that USCIS lacked inventory in the EB2 and EB1 categories to issue all the visas they had available. That was all part of them screaming, hey, 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 get us green card cases in the EB2 category because we can approve those. What else is here on the list? So a common question is, what does it mean that my case has been transferred to another USCIS office? And the bottom line here is USCIS indicates that a transfer notice is indicative of activity in the processing of your application. So when USCIS moves your case, that is a good thing. It means somebody is moving your case so they can work on it. Great. So, however, they say basically not every case is going to be processed by moving it. And they say not every application with an approved petition or an available visa has been targeted for transfer to a field operations directorate immediately. So basically, they're saying here that they aren't going to be moving all cases out to domestic field offices. And as we've explained before, there are some cases they're going to be keeping in Nebraska and Texas because that's where they're working on them. That's where there's an officer already working on it. So I guess, to take these 2 points together, it's, they are moving cases to the local field offices, but don't necessarily panic if your case hasn't been moved yet. Let's see here. One last thing I think I wanted to hit on was the fact that USCIS acknowledging that lengthy processing times at the Texas Service Center and Nebraska Service Center. And essentially what they say here is when the process, the processing times at Texas and Nebraska seem to get longer as the end of the fiscal year approaches. But rest assured, this is mostly a function of USCIS moving work from these service centers to the National Benefits Center, leaving behind a smaller number of cases with a higher proportion of outliers in terms of processing times. So I guess what they're saying is, hey, if your case is in Nebraska or Texas, your case really isn't moving slower. It's just there's some stragglers there. And basically, our longer processing cases are in those service centers. That's why you might be seeing longer processing times on the website. So, executive summary. There's an interesting FAQ out there, CIS, on the subject of employment-based green cards and how they're doing for this year. They're talking a big game, saying, hey, we're on track to use all of our employment-based green cards that we have available to us. They haven't given us hard numbers, but they're saying we're ahead of where we were last year. And considering that they only issued 175,000 employment-based green cards last year, they darn well better because they have 180,000 to go through this year. So our sort of feature issue for tonight is Sam and myself talking about, employment-based green cards. We thought it was a topic that we really need to hit, so I'm going to put it up for you. Enjoy.
So green card EAD, or an employment authorization document pursuant to an adjustment of status petition, is a topic that has not complex, but definitely has a tricky things in it that's worth spending 20 minutes to talk about.
Oh yeah, it's an exciting topic. They bring so many. I'm always excited about people getting green card EADs, Sam. They bring so many interesting opportunities and, like you said, potential challenges to people.
So kind of what it is, so people know what we're talking about. You file an I-140 petition, for example, an immigrant petition, whether it's labor certification or EB-1 without labor certification, national interest waiver, whatever. And then sometime concurrent or sometime later on, you file an application called adjustment of status.
Yeah.
And when you file this adjustment of status, this is the document that upon approval, you get the green card.
Green card, yeah.
Yeah. So when you file the adjustment of status, you are entitled to file for a work authorization.
Yeah. An interim benefit, a employment authorization that's not your green card, but allows you to work while that green card is pending.
We're not discussing the other document that you can do, which is the advanced parole, which is the allow you to re-enter the U.S. Upon a short departure. We're not going to talk about that. We're going to talk about the employment authorization document. So when you get this employment authorization document, there's all kind of intricate rules that come into play that they don't explain to you.
No.
And you should know about.
Yeah.
And how is by listening to one of these sessions.
Let's hit sort of like the main key bullet points about them right now. So presently, as we speak, they're typically authorized for about 2 years. And in the past, prior administrations have changed them, and ultimately they do that for there's a couple reasons behind the duration they approve. One, they think you're going to need them because they know it's going to take some time to approve the green card. And you were speaking earlier, Sam, basically, it saves them some work, right? It saves USCIS some work. The longer they approve a green card EAD is the less soon they have to approve another one for you.
Less
right?
application have to do, especially if they don't charge a fee for it.
They don't charge. Oh, why don't they charge fees for this, Sam?
Well, it's a long history.
Yeah.
Bottom line is about maybe 10, 15 years ago, they jacked up the adjustment of status fees so high, like from what it was to what it is. Now, I don't remember the numbers offhand without looking them up, that they were too embarrassed to charge a fee for the EAD. And they said, oh, but the EAD will be for free. And at that point, there was a mentality that we're not going to have a backlog in green cards. We're not going to have to renew them. Well, they were wrong.
Yeah.
And then it has been for free since.
Yeah. So So the big thing that people should probably know about this, at least from my perspective, is that people say they're on EAD status. They're on green card EAD status. And as an immigration attorney, that makes a little vein go off in my head because having a pending green card and having that green card EAD is not an immigration status. It's what we would call a PASA bag, or a period of stay authorized by the Attorney General.
Well, potato, right?
Okay.
For people who are not attorneys, for them, am I legal here? Am I not legal here? And you are legal if you use your EAD while the adjustment status is pending. What Brian is saying is the word status is what we call in our business term of art. It's a legal term. And it has all kind of things that hangs on it. And the adjustment EAD doesn't have those things, so it is not a status.
Yeah.
Status is H-1B, F-1. Permanent residency is a permanent status. Adjustment status is called adjustment of status, not a status. Yeah. And the employment authorization that comes with it is not a status.
Yeah. So the big point for me is, once you have that pending green card application, having the application pending means you're allowed to stay in the United States while it's pending, even if you don't have another status, H1, L1, F1. And they give you this green card EAD such that you can work while the application is pending. So even if you can't maintain your other status anymore, you get that EAD in your hand, you can work. You're in a good spot. They don't want to punish you while you're waiting for your green card, and especially because they know that your green card, it's going to take a long time for them to approve, especially now. So.
And I should add about the combo card, because the combo card is history now.
Yeah.
There was a time that they were issuing the employment authorization document and the advanced parole approval in one document, and what we used to call combo card. The law hasn't changed. It was convenient at one point to do it together, And when things get out of control, it became inconvenient to issue them together and not practical. So they just basically went back to what they used to do many years ago, is issue separate approvals for them.
So the typical result of that is you're probably going to see that EAD approved first and advanced parole come in the mail later.
Yes. Yeah. So that's what the employment authorization document is. And it does have an interesting interplay with your non-immigrant visa status. So what's a non-immigrant visa status? Is your H-1B visa that you have, or TN visa if you're a Canadian citizen, or L visa if you're on an intercompany transferee. And then you get this EAD document pursuant to the adjustment of status, and they're like oil and water. And they don't tell you that. They don't mix very well, or they don't mix at all.
Yeah, I mean, H-1B, for example, here's how you maintain your H-1B status. You work for your approved H-1B employer, right? And pursuant to your H-1B status. And that green card EAD, even though it's perfectly legal, perfectly allowed to use it, they give it to you because you want to use it. When you use that green card EAD, it puts you outside of the four corners of the rules of your H-1B status, and you're not maintaining it anymore.
Or the TN status.
Or the TN, yeah.
Or the L visa status. Yeah. Or the F1 visa status. And my question that a lot of people would want to ask is, why do I care about getting an adjustment of status employment authorization document, otherwise known as green card EAD, if I have an L visa work authorization, I have an H-1B visa work authorization, and I'm perfectly authorized to work. And if they don't mix well and using one gets me out of the other, this sounds like this can hurt me, not help me. Why would I get one of these?
Well, for me, I think of it as just protection. You can essentially put that green card EAD in your filing cabinet, and if something catastrophic happens,
such as
you can use it. Your H-1B unexpectedly gets denied. Well, you have a pending adjustment of status of the green card EAD. Fantastic. You can still work in the United States, and assuming your green card case goes ahead. I always feel really good when people get their green card application filed because if something goes wrong, they have a safety net behind them.
And so that's for the principal. For the spouse, it gives him or her a wonderful option to work, and for the children who are authorized to work in the U.S., let's say your teenage daughter, 16, 17-year-old, she wants to do babysitting, she wants to go work at the neighborhood ice cream shop, or at the library, or whatever.
Yeah, it's frustrating for people to, kids who can't work on H-4 status, or even for the H-4 spouses, H-4 employment authorization due to slow processing times. It's really hard to maintain that right now. So it's a good thing. There's so much good stuff that comes with it.
The other thing that's really important to understand is that if you are in a country that is backlogged, such as China or India, you can only file the adjustment status is when your final action date or filing date, depending on what USCIS is adopting, it becomes current for your case, meaning that your case is ready to be filed. So when you file that and you file all those employment authorization documents for you and your family, and let's assume that the visa retrogresses, moves back.
Yeah, and that's something I'm worried about for the future, for sure. Yeah, when your priority date retrogresses, it doesn't undo that employment authorization. Your adjustment of status is left pending, and you're able to keep on filing these EADs until your green card's approved.
So if the journey takes 5 or 6, 7 years to get the green card, and I know it has taken more than 10 years for some people, and you were one of these lucky people where the visa bulletin moved forward so much that it included you early and then moved back, unfortunately, but it does to most people, your family, your children, It's
a huge benefit. I guess the overall moral of that is file your adjustment of status as soon as you can so you get those interim benefits. And obviously we always hope that somebody's green card is going to be approved very quick such that you're never going to need them. But in the crazy world we're living in, if that could really just make your life so much better to make that happen.
And the EAD is renewable indefinitely until the green card is approved, regardless of how much it retrogressed. For you and your family, which is for anybody who has a pending adjustment status.
Yeah.
Good. So, but it's tricky sometimes.
Yeah.
And we kind of wanted to present how tricky it is. So we felt maybe a hypothetical or two.
Yeah,
would be best.
we have a couple of hypotheticals, so let's put one up on the screen here.
All right, sounds good.
There it goes.
So here we have hypothetical number one. John Doe is working on a green card EAD when that green card EAD expires. So he switches to an H-4 EAD, which he has already in his possession because he is the spouse of an H-1B visa holder. Any problem with that switch? Brian?
Well, this goes back to the oil and water issue. So when John Doe is using that green card EAD, he's using the green card EAD, he's definitely not in H-4 status anymore.
So this John Doe opened his drawer and he sees two EADs in front of him. And he says, one is for the H-1B, one for green card. I don't care. Both are EADs. Both are work authorization. Grabs the first one.
Yeah.
He happened to grab the
adjustment
EAD and goes in, presents it to his job. Let's say he's getting a part-time job or he's getting a job, and presents that green card EAD, and they complete the I-9 form and begins working on that green card EAD. That moment,
he leaves behind H-4 status, and that's fine. You're allowed to do that. You're allowed to use this, and the pending adjustment allows you to stay. The green card EAD allows to work. But what about when that green card EAD expires, and you look in your drawer and say, "Oh yeah,"
open the other drawer and say, "Oh, I got this other one."
Yeah, and on its face, it's a perfectly good, EAD. It's still valid, and can you use it? And the answer is no, because that EAD is only allowed to be used when you're in valid H-4 status, and using the green card EAD made you leave H-4 status behind.
So what happened to John Doe when he went back to his employer and says, "Hey, great news, I got this other EAD," and the employer says, "Oh, I'm so happy because you're such a great worker.
Yeah.
Let me record this on an updated I-9 and get back to work."
The employer's not going to say anything about that.
They don't know.
They don't know.
They're not immigration experts. The John Doe doesn't know what's happening. So what is John Doe accruing right now?
Unauthorized employment.
Unauthorized employment. And if John Doe crosses, what's that magic number?
180 days.
If John Doe crosses 180 days working on the H-4 EAD,
with working without work authorization.
He is that H-4 EAD is really not.
Well, let's rewind a second, Sam. Why does the 180-day magic number come from? There's a law called INA 245K, which basically allows employment-based adjustment applicants up to 180 days of status violations for status violations, and. This is a scenario where somebody could think they're perfectly in compliance with the immigration laws, working pursuant to an actual EAD, and in fact they're accruing unlawful presence. And when you get beyond that 180 days, USCIS can deny your green card application.
Yeah, and that can be really a problem for you. So, and you have no idea. You could be doing this for a year. Maybe you just don't even bother to renew that
green card EAD.
And then you're just saying, I got this EAD valid for 10 months, 11 months. I'm working on it. I'm not bothered by it. I'll renew the other one. Or maybe you filed for a renewal, but because of the delays, they won't give it to you for another 10 months. And now you're on that H-4 EAD for 10 months, and you really got a problem.
Yeah.
And that does happen 100%, and we've dealt with those issues.
Yeah, I mean, these things can manifest when USCIS in adjustment of status cases will occasionally issue RFEs saying, hey, explain how you were work authorized for this period of time,
We see here that you have had W-2s, you have had tax return during that period, but you were not authorized, and you proudly present the H-4 EAD card.
Yeah, and an astute USCIS officer can say, well, nice try, but...
And there's no bell that rings. When you make an error on a computer program or something, there is kind of an error message that says, try again, or this procedure is invalid. You're attempting, an error message.
For the
contact support, you don't have administrative right to use this.
Yeah,
whatever.
When I talk to people about my job, people have the impression that the U.S. immigration system is so competent that they're going, as soon as you run afoul, that they're going to snatch you up and tell you what you're doing wrong, kick you out of the country.
Yes.
It's not like that.
Yes.
The government is happy to find an error, years down the road that they missed and make it a problem for you, which grows up even bigger.
What about the reverse?
So going back to the drawers, on that fateful day, you look in the drawer, you see I have 2 EADs. I'm going to use the H4 EAD.
Or you happen to grab the H4 EAD by accident
Yeah.
because you don't know the difference between the two. And
You have your eyes closed, and just by flip of the coin, you grab the H4 EAD instead,
And
and
you-
you hand that to your employer and start working pursuant to that. And then that expires, and you hand them the green card EAD.
that scenario, there's no problem.
Yeah.
And there's no work without authorization. You cannot get back on H4,
Yeah, you leave your H4 status behind when you use that green card EAD.
which is not a big deal, but you are not accruing unlawful presence, which is crazy.
Yeah, you're
You're not accruing
unlawful employment.
Unlawful employment, or you are not in INA 245K territory. You are perfectly in maintaining proper status or proper immigration.
Yeah, and there's a question: is USCIS going to catch this? And the answer is, I don't know.
Maybe not. But
If they do catch it, they're happy to. They're obliged to act by the law when they see an issue come up. So, yeah. So, Sam, I thought that was a pretty interesting hypothetical. We have a couple more coming. So let's see what we got here.
Yeah. All right. So you are on H-1B status and have a green card EAD as well. So your adjustment status is filed. You open your own business. You stop working for your own business, and then you open your own business and you work for your own business. So you're using your EAD card for your business, and you're also working for your employer. You stop working for your business. Maybe things don't go as expected.
Yeah. You leave it dormant for a while, sure.
And you decide not to renew your green card. So your green card EAD expires, but you continue working for your employer.
Oh, that's okay. I have an H-1B approval. Aren't I fine?
Yeah, no, it's a big problem.
Yeah.
Because the moment you start working on that green card EAD, your H-1B ceased to be valid. And that's fine. So far, no violations because you have an EAD card that you're using. And when you stopped working for yourself, still there's no problem because you have an EAD card that would cover you when working for your employer. And then the green card EAD expires, and you show up to work thinking that H-1B will carry you. And then now you're accruing
another great scenario.
Illegal status in the U.S.
Nobody's going to tell you. Your employer, for which you had an initial H-1B approval, they don't know about your business, and you probably don't tell them about your business on the side, and they'll say, "Oh, cool, you're still on H-1B status, great." And how's that going to manifest? When you go to extend your H-1B status, USCIS can say, "Hey, we know, they can learn about your other business, and that's that, Or more likely, in the context of your green card application down the road, they're going to see your taxes, they're going to see some income from your business, a pay stub from your business, that sort of thing, and that could be quite a while down the road, that they discover this.
And that's the problem, you are on H-1B, you get 3-year H-1B, you jump in, you get employment for 2 or 3 months. It doesn't work. It's making you stressed out. It's not making enough money. You say, heck with it. I'm done with it. I love my job. I love my company. They pay me well. They treat me well. And then you go back and work, and then the EAD expires. You said, I don't ever want to work again for myself. And boom, now you are into a bad situation. And then if you cross the 180 days, the adjustment status may not be approvable.
Yeah.
So that's another scenario. All right, what's the third scenario we have, Brian, here?
Let's see here.
All right.
So I'll read this one. So the H-1B holder has a green card EAD, and the H-4 spouse holds employment pursuant to H-4 EAD. The H-1B holder then uses the green card EAD. Is there any problems?
So the H-1B holder got off H-1B. Yeah, of course, is a problem for her.
So
not for him. He got his wife in trouble.
Yeah. Now, if the wife has a green card EAD in the background that we haven't disclosed in these facts, she's fine.
But if she doesn't,
for
various reasons, it could happen.
I can think of a couple scenarios. She didn't choose to file for adjustment of status at the time the primary applicant did. There's a lot of times that happens. Chose not to apply for a green card EAD. Green card EAD is just delayed due to an RFE or something like that.
All kinds of reasons.
Yeah.
Absolutely. And then he just got his wife in trouble.
Yeah.
Or she got her husband in trouble, depends.
Yeah,
Now,
I guess
would that be under the, and that's that question, would you think, would that be under the INA 245K excusable mistake because it was not her doing, it was another person's doing, and the spouse did not have any knowledge of the.
that's
You argue that you hope they'll buy it, but
Yeah,
it is
I mean,
definitely an exposure.
as I recall, they don't even consider bad advice of counsel to be an excuse on that front.
But
There's
that's without,
controversy
her,
there.
without that person's control.
Yeah.
She had no control. She had a card. She's working on that card.
Well, you know what? We have a saying, Sam. It sounds like a great appeal. I would rather not have to argue that question.
Exactly,
whatever.
but those are the kind of things we think of as attorneys trying to resolve this thing. But clearly, on the face of it, that person has lost their status, and that EAD becomes not valid because that person is not on H4, and that's that.
Yeah. So I think
All
we
right.
sort of have one more hypothetical, Sam. It's
Yeah,
sort of like
let's do
the inverse of that one. I'll put it
Okay.
up on the screen here.
Yeah, please.
So the H4 spouse also has a green card EAD, and he uses, and so the H4 spouse uses the green card EAD, and meanwhile his wife is working pursuant to H1B status. So does it create a problem when the dependent uses the green card EAD? Does it in any way sort of roll up to the H1B holder?
Doesn't look like it does, Brian, in
Yeah.
my opinion. What do you think?
It doesn't. So this sort of helps us illustrate the point. So somebody's H4 status is derivative of the primary H1B holder. H1B, as long as the H1B person is maintaining their H1B status, so can their family members by just being related to them. But if the H1B holder abandons their H1B status, so does all members of the family who are on H4 status. Those folks can't maintain H4 status without the primary H1B being on H1B status. However, it doesn't roll upward. If the whole family is on H1B and H4, and everybody has a pending green card, and those kids who want to take those summer jobs, at the ice cream store, use those green card EADs, it doesn't roll over to other family members. Dad, the primary H1B holder, that kid using that green card EAD does not impact his H4 status. They derive from him. He does not derive from them.
Excellent point.
Yeah.
And that's it.
Yeah.
H4D. Back to Brian.
Well, that was it from me and Sam. I like those guys. I thought they had some good things to say. So now is the time where I'm going to add sort of one thing that we didn't discuss in that bit of our presentation. Now, Sam and I talked a lot about, make sure you use the right EAD. It's worth noting that you have the right EAD when you've picked it out when you can read the category on the EAD. Your adjustment EAD should be marked C09. In the case of an H4 EAD, would be C26. If you're dealing with another category of EAD, you can of course look that up online and figure out which one's the right one. Identify it, what the identifiers are. So that's the midpoint. I'll be back in just a moment with taking some time to answer your questions. I will see you then. Well, we are back, and it's time to answer your questions, and it's always a favorite part of our little show here. So a question from Sweet Seller, it's after how many months of having a green card can you apply for citizenship? So the answer for most folks is you can apply for citizenship 90 days before you hit 5 years of permanent residence in the United States. For people who get a green card through marriage and are living with that spouse, you can actually apply 90 days before reaching the 3-year mark. So the general answer for employment-based green card applicants is you have to wait 5 years to become a permanent resident of the United States, and 5 years after becoming a permanent resident of the United States. So what else do we got here? Let's see. From Ashita Patel. So EB2 I-140 approval in January 2022, applied for I-485, and receipt date is 3rd week of April of 2022. Okay. And biometrics is next week. A very good offer from another employer. When will be the safest to change employer? So ultimately, in order to keep your adjustment of status going, you cannot change employers right now. What we're talking about here is portability of jobs, and that's only allowed after your I-45 application has been pending for 180 days or more. So really, at this time, Ishita, you can't contemplate changing employers pursuant to the I-45 portability. Worthy to take a pause and just note that, I'm answering, it's one of our favorite things to do, take these questions live and answer them, but immigration issues are nuanced. The answer is usually never yes or no, and nothing beats the advice of, talking to an immigration attorney specifically about your issues, because, this question from Ishita is probably something I could talk to her for the better part of an hour for. So, let's keep it going though, and let's see what else we have here. So from Kumar, I have an EB2 I-140 approved and downgraded to EB3 on October 2020 with employer A, and in January 2022 took a new job with employer B, H-1B transfer, and I-45J in March 2022. Am I eligible for TUB? Transfer. So for everybody, it's a fun word for me. What Kumar means by TUB is transfer of underlying basis, or sometimes called an interfiling. Can he move his adjustment to another category? And I presume, Kumar, that you're looking to get yourself back into the EB2 category because the EB2 priority dates are so much further ahead. So you are eligible for the TUB provided you have an offer of employment in the EB2 category. And the problem I see for you, Kumar, is it looks like you have an EB2 I-140 approved with your prior employer, but not one with your current employer. So I see sort of two paths for transfer of underlying basis for you. It is in theory possible for you to go back to your prior employer and say, hey, this prior employer is offering me an EB2 position. I want to transfer my adjustment of status to that. The alternative would be for your new employer to obtain an EB2 I-140 approval for you. And that's a process that takes a while right now due to big backlogs with the Department of Labor. But ultimately, that new employer can get an EB2 I-140 approval for you, and you can transfer the underlying basis of your I-45 from your EB3 to that new EB2 I-140. So the option's open, but it just requires some planning. From Ajay Shah. So where should I send my medicals without RFE? I filed for I-45 to TSC in 2020 under EB2. I interfiled in April to California. Receipt received from MSC. Where should I send medicals? So Ajay, I don't know if you saw the first half of our presentation, but I can put it up on the screen right now. USCIS has told us that, hey, we do not, there it is on the screen. Non-citizens with pending adjustment of status applications should not send unsolicited I-693 medical exams to USCIS. And why do they say that? Because it is likely for them to lose it right now. Just based upon the way things are there, they say if we get it now, we will have trouble matching up with your case. Ultimately, as a matter of practice, you would send them to USCIS at the office where your case is. So if your case is in the national, if they're telling you their case is with the National Benefits Center, that's where you would send it. If it's in Texas, you would send it there, et cetera, et cetera. If your case is at a local field office, you might be able to ascertain that information from contacting USCIS. However, you really do have a challenge there in that they're not really great at giving that information. But ultimately, USCIS says, hold on to your medical exams until we ask for them. And so they might ask you for them in an RFE. And the other alternative is if they call you in for an interview, they can accept them at that time. So from JCP Ready, do you get the sense that final action dates will move to mid-January 2015 in the next bulletin? I do not think so, and I'll explain to you why. So USCIS, if you look at their case inventory as of Q1 of fiscal year 2022, which they published back in March, they said that they had 285,000 employment-based green card cases in their hands. And we know that for this fiscal year, that they have 280,000 green cards available, right? So that means they already have in their hands more green cards than they can issue this year. And I know back in October of 2020, the furthest they moved the visa bulletin was for the EB3 category to January 1st, 2015. A little bit before mid-January, when I presume your priority date is JCP ready. So what does that mean for me? If they move the visa bulletin ahead right now to January 2015, to middle of January 2015, they will get more green card cases in. And they don't want that because they know they don't have the visas available for that. So JCP ready, my honest answer is you're more likely, I guess I wouldn't consider it totally crazy if we saw some movement beyond January 1st, 2015, soon. However, I think the more likely time you're going to see it is in the beginning of the next fiscal year, which would be on the October visa bulletin, which will be very interesting to see because there's so many questions that will be answered there, like, hey, is there a massive visa rollover from the family-based categories? Things like that. And let me see, I think we have a little bit more from JCP ready. Yeah. Exactly. I think the way they're moving the visa bulletin right now, JCP ready, is that they may have moved the visa bulletin enough such that they do actually have enough demand to adjudicate all those EB2 green cards. What else do we got here? So from Sagar Kulkarni, hello. Refiled EB2 in April 2022 at the NBC, and the final action date is current. Got an RFE on the I-140 for downgrade EB3 filed at SRC in October 2020. Will the RFE hamper the process of the EB2 non-concurrent case? Thank you. So, when I first started this presentation, I went over this recent USCIS FAQ on the subject of employment-based adjustment of status processes. And this is a question they actually answered in this FAQ as well. And I will show it to you if I can find it here. Let me see here. Here we are. So this is again from that same FAQ recently published by USCIS, and here's the answer to your question right here. If the immigrant visa petition underlying my pending adjustment of status application has not been adjudicated, will this prevent me from transferring basis to a different petition? And the answer is, a pending petition does not preclude us from granting the applicant's request to transfer underlying basis to a different I-140. So this is something we already knew. It's really good to see USCIS making it extra clear for people in this FAQ. But this is actually something that's well published and well known. It's in the USCIS policy manual as well, that it very clearly explains that you can go from a pending I-140 to an approved I-140, which is what you would be doing. Let's see what we got here. Back on the main view. So from Sagar again, are we seeing delays from the Texas Service Center with I-140 RFE notices being delivered to mail? RFE issued on June 2nd, but nothing received in the mail yet. Should I file a service request? So yes, we have been seeing this, the USCIS just not sending RFEs, and the answer to the way to resolve that is with a service request. From June 2nd, about over 2 weeks now, I think it's probably appropriate for you at this point. I would note though that they will not allow you to put in the service request, Sagar, on your I-140. Why? Because that is an employer-owned case, and that's just how it works with USCIS. USCIS will not accept a service inquiry from the beneficiary. It has to come from the employer or their counsel. So from Srivan Kumar Vanaparthi, its question is, it's a good one. I've interfiled last week. When can I expect my green card? Also, do you see any approvals for interfiles? So we are seeing some approvals for interfiles. It's not as fast as we would like, and there are some people I know out there who have had interfiling requests put in a long time ago, and they have not seen results. And conversely, I know people who have put in interfiling requests quite recently, And, we have seen nothing. And it's very frustrating. So the hope is, and based upon everything we've seen from USCIS, including the FAQ, which I sort of, took you guys on a speedy trip through earlier, is that USCIS is intending to use all these green cards. And in order to use these green cards, they're going to need people with current priority dates. And Srivan, basically, if you've interfiled and your priority date is current, you, in theory, could get one of those green cards this year. I would sincerely hope you do, but what USCIS does, they're talking a big game right now. Whether they actually achieve that goal, whether they issue those green cards, is something which we're just gonna have to wait and see. Okay, I'm gonna keep on moving here. From Lucky. Hi, Sam and Brian. I'll give Sam your regards. With only 2 more visa bulletins remaining, how realistic is that USCIS is going to approve the employment-based green card applications filed so far? Will there be any spillover for this year? So, I maintain a healthy skepticism that USCIS will issue all these green cards. For those who weren't present earlier, I'm going to try to put up on the screen the quote that USCIS has recently put out in an FAQ on their website on Friday. And let's see here. There it is. It says, as a result of their work to do better, we are well positioned to use all of the available employment-based immigrant visas in fiscal year 2022, despite the higher annual limit versus what they had last year. So that is USCIS talking with some great optimism, which I like. But like I said, I am skeptical. That is essentially, 80,000 more green card approvals than they did last year. And they are also in this FAQ, I won't bore you all by putting it up there, they're saying right now, they are using twice as many visas, green cards, permanent visas, as right now as they were using this time last year. That's great. It makes me optimistic, but we will only know when the fiscal year is closed and when USCIS publishes the numbers. I think that they really feel the magnifying glasses on them, that they know a lot of people are upset about how things went last year, and I think they're trying their best. So the next question that you have there, Lucky, is an interesting one for me. It's, will there be any spillover for this year? I am not optimistic on that. So, spillover, for anybody who's not aware, spillover comes when the massive extra amount of green cards available this fiscal year comes from when when there were unused family-based green cards from last year and the last couple years. And the reason why there were so many unused family-based green cards is due to COVID. Most family-based green cards were issued through the consulates abroad. And the U.S. consulates abroad were mostly closed for a large portion of the last 2 years. Why? Because, well, COVID made them close. And essentially, they weren't issuing family-based green cards much at all. And when family-based green cards aren't used, the way the law works is that they spill over, like Lucky said, into the employment-based category. Now, one of my hobbies is to check on how the Department of State is doing. If you guys do a Google search for Department of State visa issuance statistics, you will see that they publish on a monthly basis. They're a couple months behind, but they publish on a monthly basis how many green cards they issue. And I look at this at a very broad level, and I basically look at to see how they're doing now and how does that compare to pre-pandemic levels. And my honest assessment is right now, they're really kind of back to their pre-pandemic levels in terms of visa issuance, green card issuance, which is mostly family-based green card issuance at the consulates. And if they are back at pre-pandemic levels at the consulate, it means that it is increasingly less likely that there will be spillover in the new fiscal year. I can't say that there won't be any at all, but when I'm seeing, the bottom line is when I'm seeing their monthly visa numbers from now, monthly visa issuance at the consulates now reflects similar numbers to see what I was seeing in 2017 and 2018, pre-COVID. It points to me that there won't be much spillover opportunity. That's a good question, and it's one I think about a lot. So from Sriva, can H-1B work multiple clients for the same employer? Any hours limitation for extra work, can it be 40 hours extra? If yes, will the extra salary coming from extra hours count toward the H-1B salary? So this is a question which, we could have a very long conversation about, Sriva, and I'll try to keep it relatively simple so I don't bore everybody. So USCIS, your H-1B job is whatever USCIS has approved. So in your H-1B petition, it says who you're going to work for, how long you're going to work, and how much money you're going to make, right? And USCIS has a pretty clear policy that anytime there's a material major change, that an amendment is required. It is not very well defined what a material change is, and thereby, in most cases, what an amendment, when an amendment is required. But you're telling me, that you're taking on more clients, doing significantly more work, and will be making significantly more salary. This is the sort of time where you might want to talk with your employer and their counsel as to whether or not an H-1B amendment is necessary. The answer isn't necessarily yes, but it sure is certainly a conservative answer, and it's a conversation that should be had, if not necessarily an amendment being filed. Let's see what we got here. So from Sarisha CH, well, hi, hello, good evening, or good late afternoon, depending upon where you are in the country. In I-45 for Indian employer name, I made a typo mistake. Will it be an issue, or what is the process to notify USCIS for the correction? A great question. So ultimately, for me, Sarisha, it really depends upon what the nature of the typo is. I mean, in the name of a company, that sounds like a really minor error. If it's pretty clear who you mean, and it might be the sort of thing you can let go. However, I can't really say for sure whether it's going to be an issue because take your green card filing seriously. USCIS does. They've issued RFE for more inane things, but ultimately the process to correct it is if you're feeling anxious about it, you can basically talk to an attorney about helping you basically send a brief letter to USCIS, adding it to the file, correcting the issue. Again, I'm not quite clear if it's something that would really concern me. It sounds relatively minor, but when in doubt, you can really send a letter to USCIS saying, hey, my name is so-and-so. I've been reviewing my green card case. I did encounter a minor typographical error that I'd like to correct. Here it is. Should you have any questions, don't hesitate to contact me. Thank you. It's something we help people with now and again. From Ajay Shah, when does the 180-day start after interfiling with I-45J? Would it be from the notice date? So one thing I'd like to be clear with you, at Ajay, is that well, first of all, let's talk about the issue you're discussing a bit more. For those who aren't aware, doing an interfiling or a transfer of underlying basis with I-45J, that restarts the 180-day portability time frame. So Ajay, as I understand, is asking the question, hey, if I did an interfiling, when does the 180-day blackout period, by which I can't change employers again, start? So it's a great question. For those who don't know, you don't get a receipt notice for your interfiling request. An interfiling request is really just a letter that you submit. However, at that same time, you are required, per their current policy, to submit a Supplement J. And that Supplement J would come with would eventually generate a receipt notice or a receipt notice. And I guess I want to point out to Ajay is that there's going to be two dates on that receipt notice regarding the Supplement J. There's going to be a receipt notice indicating the date they received it, and the notice date. The notice date is actually the date that USCIS issues a notice. So receipt means this is the day we received it in the mail, and notice this is the date we sent the notice. Receipt date is generally what you would want to be talking about on this, because again, that's from when you made the interfiling request would likely be the receipt notice. There you go, a receipt date, excuse me. I guess I would encourage you to tread lightly on these things because it is your green card that you're playing with. Make sure you're sure about your dates. Here we are. From Sudha Mahadevi. My child is 17 years old, is on H4, and has an individual taxpayer identification number. She is receiving SSN when we filed for AOS EAD. Our priority date in EB3 is not current. Shouldn't she use the SSN, and can she continue using the ITN? We prefer H4 for her. So, a pretty good question. So, having a social security number is, I guess the question is what is she using that SSN for? If she is working, if she's using that green card EAD and that SSN to work, she's abandoning her H4 status. I'm curious as to how she would have it. Why would she'd have a need for a taxpayer ID? Because as a child on H4 status, she would not have the means to work in the United States. So I think I need a little bit more information, Suba, to really give it a more intelligent answer on that question. But basically, if you use, for anybody who's not clear on the subject, if you use the benefits associated with a pending adjustment of status, like the EAD, that makes you abandon the H4 status in this case. Oh, there's a little bit of follow-up from Suba. So, yes, so she'll be attending a 3-week research program and want to provide a stipend for transport and food. This is not employment / job. Is it a stipend? Can she take it? So, Suba, that's the sort of thing where my honest answer would be you might want to consult with an attorney on whether that's considered employment. It's the sort of thing which might be beyond the scope of this sort of presentation. I think there's a good argument to be made, but I think you'd rather be careful. Obviously, there's a benefit to maintaining H4 status, but ultimately, that green card EAD is there as a backup. So. So does using the EB3 EAD lock me into that specific adjustment of status? I have an EB2 AOS pending. So reasonable minds on this subject can differ, but there's no USCIS policy that indicates that using an EAD AP from one category locks you into another adjustment of status. That's a simple answer. So, my EB3 is current and moved from the Nebraska Service Center to the National Benefits Center, but I do not see the option of National Benefits Center to check the processing times. Is it only a placeholder? Here comes the rest of it. And should I expect the case to be transferred to a field office? I think there's a little bit more from MN here. This is regarding an I-4, and this is regarding an I-45. So, great question. So more or less, I would agree with you in calling it a placeholder. So a while back, I think this would have been in March or April, USCIS issued a policy notification that said, hey, we are moving cases from Texas and Nebraska because they're a little bit backed up and moving them to field offices. And this is manifest through them being sent to the National Benefits Center. So it is more likely than not, MN, that your green card application is in a local field office. And I know your transfer notice is not going to say which specific one. I have heard anecdotally that that by contacting USCIS on the phone or through the EMA online agent, they may be able to tell you which specific field office you're in. I would always take that information with a grain of salt because USCIS acts through writing. They act through official receipt notices, and that's why I say, as a matter of a rule of thumb, you can take with a grain of salt what you hear from those services. So odds are they've moved your case to a local field office, but I just really can't say for sure. It's about 7 o'clock here, so we're going to take just 1 or 2 more questions. So from Siva, are they issuing interviews for EB2 refiled cases? What percentage? So not clear on that. If you read this FAQ available on the USCIS website right now, published on the 17th, just a couple days ago, USCIS can issue an interview notice for whatever case they want. As they explain in their FAQ, they're basically trying to avoid those and trying to make smart choices to only interview people they really need to interview. Common interview triggers are typically, maybe if there's some typos in the form that confuse them. Common one we see is people with minor criminal stuff. These are the sort of things which are more likely to generate an interview. The vast majority of employment-based green card cases right now, per policy, are not getting interviews. And I am going to do my best to take one more question, and we'll see what that is. So for Srinivas Thota, my I-45 application moved to the NBC office on December 15th. So when I check my processing times, do I need to check the service center or my local field office, i.e. the NBC? So this is a question that's honestly flummoxed me for a while, Srinivas. So as I was just talking earlier with regards to a previous question, a case being moved to the NBC typically means that it's being sent to a local field office. However, what we have seen pretty consistently is that it won't necessarily be sent to your local field office. These cases are being sent to field offices where they have extra bandwidth. So, we've seen, cases from people in Ohio being addressed by a field office in Florida, and any number of combinations of that. So I mentioned my previous advice earlier is you may be able to contact USCIS via their 1-800 number or the Ask Emma agent, and they might be able to tell you what local field office the case is at. And there you go. So it is, all right, I'm Brian, so I'm going to just take one more from Sandfax. October 2020, filed my I-45 EB3 downgrade. Priority date, May 2013, EAD, AP received. Wife on H-1B, got laid off. Is there any issue with traveling to India and coming back on advanced parole? So it sounds like you are probably the dependent of your wife who got laid off on H-1B. Well, I guess there's probably a little bit more information I would need there, because if your wife is the primary visa applicant, my concern was that it would be that she doesn't have an offer of permanent employment, and it could cause questions as to whether or not she's still eligible for a green card. And really, I think if your wife on H-1B is the primary visa applicant, my number one focus for her, because I'm a conservative guy, is to make sure that she has an offer of employment, of permanent employment in place, through a Supplement J portability filing. And then you might consider thinking about travel, because I worry about coming to the border and, some officer saying, hey, what's the status of your green card case? And if the answer is, I don't have a job right now, that might concern me. My programming as an attorney is to do everything I can to protect the green card. And if any time spent without an offer of permanent employment in the United States really, really does stress me out. All right, everybody. It's 5 minutes past 7 o'clock. I've already gone over my time. Thank you so much as always, and we will see you again next week. Bye-bye.